Hello, my name is Tony Nicholson, and I'm an estate planning attorney in North Carolina. And I'm going to be speaking with you today about estate planning, getting your legal affairs in order. So, what kinds of legal documents are appropriate for you to have to get your legal affairs in order? So, there are two different phases of estate planning. The first phase is estate planning in the event of your incapacity. So you're still living and you lose capacity and you need someone to handle various affairs for you. That's the first phase. And then, of course, the second phase of estate planning is the planning for your death. And so in this phase, we'll talk about for this phase, we'll talk about your will and other ways of passing property to your heirs upon your death. And there are documents that are important in both of these phases, and we're gonna talk about each one of these separately. So I'll start with the planning in the event of your incapacity. We'll first discuss a general power of attorney. This is the main document. And a power of attorney is important because it avoids the need for court-appointed guardianship. So if you don't have a power of attorney and you become incapacitated, then someone's going to need to be appointed your legal guardian in order to make decisions for you. And that, is time-consuming and it costs money. And if you have a power of attorney, then, it takes care of that. You don't need legal guardianship. And powers of attorney can take effect immediately, or they can be set up to take effect only upon certain triggering events. That's called a springing power of attorney. I typically recommend the type that takes effect immediately, and that way it's less hassle for activating it when the time comes. And I figure if you trust someone to handle your affairs while you're incapacitated, you ought to be able to trust them to handle your affairs, while you're of sound mind. In a power of attorney, you always want to appoint successor agents in addition to the primary person or persons that you would like to serve as your agents. As I mentioned before, a power of attorney is an alternative to guardianship, and there is a big difference between powers of attorney and guardianship, and it's really the crux of it is the balance of control. So with the power of attorney, you're not giving up any rights, or you really are just giving someone else the ability to handle your affairs on your behalf. You're still in control, and you can revoke the power of attorney. You can change the terms of it. And so you're really in control when you still have when you have a power of attorney. But with the guardianship, you really are losing control. That is, a person, your civil rights are taken away and given to another person. So that's a pretty big deal. And you can avoid all that if you have a power of attorney set up for your incapacity. The next document that's useful in preparing for your incapacity is a healthcare power of attorney. And this allows you to appoint one other person to make healthcare decisions for you if you are incapacitated. And it grants some pretty broad abilities for that other person to make decisions for you, and including life support decisions, organ donation, burial. Really, pretty much any kind of medical related decision is contained in the healthcare power of attorney. Although you can limit their authority in different ways, and there are places where you can do that in the healthcare power of attorney. It's important to note that the document is only effective if you become incapacitated. So as long as you are able to, then you make your own healthcare decisions, and the healthcare power of attorney only kicks in if a doctor says that you are incapacitated and you can't make healthcare decisions for yourself. Then also we recommend there be a separate HIPAA authorization, which HIPAA stands for the Health Insurance Portability and Accountability Act. But basically it's a law that limits healthcare providers from releasing information about you, and that's good. But sometimes it causes situations where family members can't find out what's going on with their family and can't get access to medical information. So we recommend a separate HIPAA authorization for that. Another document that is related to the healthcare power of attorney is called a living will, officially known in North Carolina as an advance directive for a natural death. And this one is different than the healthcare power of attorney, though, in that it is very specific. It's really guidance about your end of life choices. So it expresses your wishes about life prolonging measures in certain situations. And those situations, there's really three main ones in the North Carolina statutory form living will. And that is if you have an incurable, irreversible condition and, doctor says you're going to pass away pretty soon, or you are in a permanent coma, or you're in a persistent vegetative state. That's another situation. And then the third one mainly pertains to seniors, but let's say you have advanced Alzheimer's disease or some type of advanced dementia, and something has to be given to you to prolong your life. Then in your living will, in these situations, you can say that you don't want life prolonging measures. And it provides guidance to your family during a time in which maybe they may be having to try to make a difficult decision, and this can be helpful. So the most common life prolonging measures that we're talking about are tube feeding, so artificial nutrition and hydration, the respirator, ventilator, dialysis, antibiotics. Those are main forms of life prolonging measures that most people would not want in certain really dire situations. And again, like the healthcare power of attorney, this takes effect only if you're incapacitated and you can't communicate, with your healthcare providers about what you want. You make those decisions as long as you're able. But if a doctor says you're incapacitated, then this will express what you want in those situations. Keep in mind that a living will is not a substitute for conversations with your family about your end of life choices. It's good, but you really do need to talk to your family as well about these matters. So to summarize, the documents needed to prepare yourself for incapacity would be your general power of attorney for financial and legal matters or other matters, your healthcare power of attorney, and your living will. Now we're going to move to estate planning in the event of your death. And there are 4 ways that property is transferred upon your death, and we're going to talk about each of these ways. But they include beneficiary designations, joint ownership of property with right of survivorship, probate, which involves a will, or if you don't have a will, something called intestacy, where the general statutes of North Carolina provide who would receive your property if you die without a will. Those are contained in the probate administration process. And then a trust is another way. We're not going to really talk much about trusts. It's really outside the scope of our discussion today, but that also is another way to pass property outside your, or that is pass property upon your death. The first one of these we're going to talk about is beneficiary designations. So, most people do think, a lot of people think that your will dictates what's going to happen to your property after your death. But as I said, there's a number of different ways that property passes, regardless of what your will says. And one of those is through beneficiary designations for assets like retirement plans, like IRAs and 401ks, life insurance policies have beneficiary designations. Annuities also have beneficiary designations, and then something called transfer on death or payable on death accounts that you can get at the bank or a brokerage company. All those different assets can pass outside your will according to the named beneficiaries on the accounts. And as I said, those take precedence over your will. It doesn't really matter what your will says if you have a beneficiary designation on those assets. So it's important to review the beneficiary designations on your various accounts and life insurance policies every few years and make sure that they're consistent with what you want and they don't create any unnecessary tax consequences for your beneficiaries. And then the next type or the next way in which property can pass upon your death is through joint ownership. And there are two types of joint ownership. One is called with right of survivorship, and the other one is what's called tenants in common. Right of survivorship is the most common, and we'll discuss that in a minute. Tenants in common is not as is common, so to speak, in as right of survivorship, but this comes into play with inherited property. Let's say that you inherited some farm or a piece of real estate from a parent, and you and your siblings inherited it, and you all own it together. Well, that's called owning it as tenants in common, and it's important to know that when you own an interest in a piece of property as tenants in common, then if you died, your interest in that property doesn't automatically go to the other owners. It goes to according to your will or your heirs. So real property with right of survivorship is very common for married couples. For example, and I'll talk a little bit more about that. For example, with bank accounts or investment accounts, stocks, or own a house or other real estate, if a married couple owns one of those assets, then when they pass, the asset is owned 100% by the surviving one of the couple. You can also own property with right of survivorship with someone else, like a child or some other person. You can own property as joint with right of survivorship. And as I mentioned, when this happens, or when this type of joint ownership is used, when you die, the property just automatically goes outside of your will to the surviving joint account owner, and it does so regardless of what your will says or whether you even have a will. And one aspect of this I want to highlight is just to be aware of some unintentional disinheriting, because oftentimes it seems like when a person starts to age, they want to put maybe they're widowed, or they want to put one of their children on their bank account as joint with right of survivorship, because they feel like the child might be able to more easily help them with their finances. But what they don't realize is that when they die, that child is going to be the owner of that bank account. And sometimes that can create a problem if the intention was that property would be divided among all the children. So we don't really recommend that. Power of attorney is a better way to allow someone to handle your affairs if you become incapacitated. The other problem is that when you put a person on your bank account as on your joint bank account, it does expose that property to any creditors of the other joint owners. So you got to make sure that the other person you're putting on there has good credit. So the next type, or the next way that property can pass upon your death, has to do with probate. And probate is really the court supervised process of administering a person's estate or distributing a person's estate upon their death. And this applies whether you have a will or not. If you have a will, that's called a testate process. If you don't have a will, it's called intestate. And this is a public process, so everything at the courthouse is public record. And the court is involved here so that there's some oversight over how property passes upon a person's death. If you don't have a will, then you have what is called an intestate estate. And so there's particular laws that provide who gets your property. Sometimes you might think, if you're married, that if you pass away, that, well, it's going to be your spouse who receives your property. But that's not the case. If you have children, then your children would share in some portion of that up to a certain amount. And so it really is beneficial to have a will, because you just don't know for sure that the laws of intestacy are going to provide that your property go to who you want upon your death. When you have a will, as I mentioned, it's called testate, and then the property will pass according to the terms of your will. So the will itself, there's a number of good reasons to have a will, and one is that you get to name who are the beneficiaries, who's going to receive your property upon your death. And if you have minor children, then in the will is a good place to put who you want to be guardian for your minor children. You also get to name who's in charge of your estate if you have a will. And if you don't have a will, then you have multiple children or others, then the statutes have a list of priority people who would be in charge of your estate. So you get to name that in your will. And you also can set up trusts for children. Let's say you have either adult children or minor children who you feel would need some help in managing their share of your estate. You can set up a trust for them in your will. It's called a testamentary trust if it's included in the will. And that is useful because you can then set ages at which points your children could receive a portion or all of their share of the trust, and you can name someone else to be in charge of that share for them. That's the trustee. And if you don't have a will and you have children, then their shares are going to go to them, and there'll be a guardian appointed for them until they're 18. And if there's anything left when they're 18, they just get it at that point. And that often is not a good idea for an 18-year-old to have access to a decent share of money. Another aspect of a will is that it really doesn't come into effect until your death. That may seem obvious, but you can change your will as much as you want, as long as you have the mental capacity to do so before you die. And so it's your last will that you do that would be your will that's taken to probate. So even though a lot of our property does pass outside our wills, if we have bank accounts joint with right of survivorship or 401ks, life insurance, the will is really important for any property you have in your individual name, and for naming the people who are going to play roles in your estate. It's also a good idea to review your will every couple of years. I mean, there are things change in our lives that require us to take another look at our will to make sure they're still appropriate. You might have new, different family circumstances. A child or a spouse could die. You could get divorced. Most of the time wills will automatically adjust to new children, but you still need to take a look at that. If you move to a different state, it's a good idea to have your will reviewed by an attorney in that other state. Make sure that it is appropriate for that state. And you may have changes in your property and your assets that you want to take into consideration in doing your will. So every few years, you ought to take a look at the terms of your will to make sure that it's still appropriate. I want to talk a little bit about the formalities and storage of wills. You know, it's not the case that you can just write a will, type it up on the computer and then sign it and expect it to be valid. There's some rules for for signing of wills and the preparation of wills. So a written will, needs to be witnessed by two people and it's notarized. There is a way to have a handwritten will and have it valid, but it's just not a good idea. It's just difficult to accomplish what you want in a handwritten will. It's just, handwritten wills are just the subject of so many court cases and lost estate funds that would have been better to go to beneficiaries than towards the legal fees that were needed to resolve disputes over handwritten wills. So just don't try to write your own will. And that's the thing is, if you have a will, then make sure you don't, and you want to change it, don't just cross out portions of it and then add new provisions in with your handwriting. It won't work. It just doesn't work. It's going to create lots of problems if you do that. So the other thing I want to mention is storage of your will. So it's good to keep your will in a safe place. It's a safe that you might have at home. If you have a safe deposit box, that's a safe place. Sometimes people say, well, you shouldn't keep your will in a safe deposit box because, once you die, then it's frozen, or you can't get in, your family can't get into it. And that's true. That is actually true. But it is a safe place to keep an original document. And I think it's most important to keep it in a safe place. And it's a little bit of hassle for the family to get in there after your death in order to obtain your original will. But I think that the bother is worth it if you can keep it in a safe place. Also, you can keep it at the attorney's office. Some attorneys will store wills for their clients. The main thing is that you just keep it out of the way in a safe place where it's not going to get lost, because you need that original. So where do you get a will? I mean, most people know that attorneys prepare wills, and that's the best place where you can get a will. So any attorney who works in private practice or who works with legal aid or a pro bono attorney, many attorneys provide wills pro bono under certain circumstances. Those are good places to find a will. There are online services where you can get a will on your own without the assistance of an attorney through an online service. I don't really recommend those, although they can be useful they're certainly inexpensive and they can be useful for very simple situations, but I've just seen a lot of situations where it just doesn't work out well for that person who got a will with online service, because it just doesn't address all the things that you would get if you had an attorney who's trained to prepare your will. So last, I want to review a couple of issues that have to do with the time we're going through right now. In these days of this state of emergency because of COVID-19, the state of North Carolina has changed the law to allow remote witnessing and notary by video conference for wills and other legal documents. And so that is permitted if you're in a high risk situation, or you're just, for whatever reason, you just can't you just do not want to leave your house, or you are in a assisted living facility or a nursing home, and you don't have access to other people who can be witnesses, then it might be possible for you to have your will witnessed remotely. But there are a number of requirements, and you really have to be careful in following the rules for that. And so it's just good to know about it's there, but if at all possible, it's just best to stick with the normal way of having two witnesses in your presence and a notary in your presence as well. So I hope this information has been helpful to you today. There are a lot of, these documents are important in preparing for your legal affairs and in the event of your incapacity and your death. And I know that from my experience, once you have these done, you've got good peace of mind. You can put it behind you and know that you have your affairs in order in case something does happen. So thank you very much and have a good day.